Melania Trump just broke her silence under oath. In a sealed deposition taken inside a federal courthouse in Washington, the former First Lady reportedly answered questions for over 4 hours, providing testimony so damaging that Trump's legal team filed an emergency motion within 90 minutes of the session ending. This isn't a rumor from anonymous insiders. This is a sworn legal proceeding that has now triggered a full-blown crisis inside Trump's defense strategy. When your own spouse provides testimony under oath that forces your lawyers into emergency filings, you know the walls are closing in fast. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what set off this extraordinary chain of events? A federal judge overseeing one of the ongoing criminal proceedings authorized a sealed deposition of Melania Trump after prosecutors argued she possessed direct knowledge of key events at the center of the case. Trump's attorneys fought the subpoena for weeks, filing motion after motion to block it. They lost every single one. And believe me, when a legal team burns through emergency motions at this pace, you know something enormous has just detonated. Here's the full picture of what's been unfolding. Tensions between Melania Trump and the former president's legal defense have been simmering for months, fueled by separate legal representation, conflicting financial interests, and what sources close to the family describe as a deepening personal divide. But everything escalated on February 11th when federal district judge Catherine Marlowe issued a sealed order compelling Melania's testimony after reviewing in-camera evidence that prosecutors said placed her at the center of critical conversations. The deposition was scheduled for February 14th, conducted inside a secure conference room at the E. Barrett Prettyman Federal Courthouse in downtown Washington. Court records show the session lasted 4 hours and 22 minutes. 3 federal prosecutors were present, along with Melania's personal attorney, 2 court reporters, and a representative from Trump's defense team who was permitted to observe but not intervene. This wasn't a routine interview or a voluntary cooperation agreement. It was compelled testimony under the full weight of federal subpoena power. Smash that like button if this is making sense so far. Here's where it really gets serious. When Melania's attorney reviewed the scope of the questioning in advance, sources say he recognized immediately that the prosecution's focus had shifted to a topic Trump's team had been desperately trying to keep off the table. And let's be honest for a moment, depositions of a former president's spouse in an active criminal case are virtually unheard of. They don't happen over routine matters or peripheral details. They happen when prosecutors believe a witness has direct, first-hand knowledge of conduct that goes to the heart of the charges. Here's what multiple sources familiar with the proceedings say happened next. On February 14th, Melania Trump arrived at the courthouse through a private entrance at approximately 9:15 in the morning, accompanied by her attorney, David Harrington, a former white-collar defense specialist now in private practice. Sources told legal reporters that Melania appeared composed but visibly tense. Inside the deposition room, lead prosecutor Margaret Chen began with foundational questions about Melania's daily routine at Mar-a-Lago during the period in question, specifically the months between January and June of 2023. Meanwhile, Trump's legal observer, identified as associate counsel Derek Stafford, sat in the corner of the room taking handwritten notes. By the second hour, the questioning had shifted dramatically. Prosecutors began asking Melania about specific conversations she overheard between the former president and his personal aide regarding the handling and relocation of classified materials. Sources who were briefed on the deposition say Melania confirmed she was present during at least 3 separate conversations in which documents were discussed. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. According to sources briefed on the sealed transcript, Melania testified that she personally witnessed boxes being moved from a storage area to the former president's private residence at Mar-a-Lago on a specific date that prosecutors had previously been unable to confirm through other witnesses. She reportedly described the scene in detail, including who was present, what time of day it occurred, and a direct instruction she overheard regarding where the boxes should be placed. That's when it became clear this isn't just another deposition. The bombshell moment came when Prosecutor Chen asked Melania directly whether the former president was aware that the materials in question had been requested for return by the National Archives. Sources in the room say there was a pause lasting nearly 15 seconds. Melania's attorney conferred with her briefly and then she answered. Sources familiar with the testimony say her response was unambiguous and devastating to the defense's central argument that Trump was unaware of the specific nature of the documents. This sent shockwaves through the legal community. When a defendant's own spouse provides testimony under oath that contradicts the core defense strategy, it doesn't just create legal problems. It dismantles the entire framework the defense has been constructing for months. The claim that Trump had no personal knowledge of the document's classification status collapses when his own wife, under oath, places him in direct conversation about their handling. This isn't the first time testimony from an insider has reshaped a major political legal case. Think back to John Dean during Watergate. Dean, Nixon's own White House counsel, testified before the Senate that Nixon had been directly involved in the cover-up. That testimony shattered the White House's defense and ultimately led to Nixon's resignation. The parallel is striking. When the people closest to a president start telling the truth under oath, no legal strategy can hold. Then there was Michael Cohen during the first round of Trump investigations. Cohen's congressional testimony where he called Trump a racist, a con man, and a cheat was dramatic. But the key difference is that Cohen was a known adversary by that point, already cooperating with prosecutors. His credibility was contested. Melania's testimony carries a fundamentally different weight because she has no cooperation agreement, no plea deal, and no obvious motive to fabricate. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the Mar-a-Lago case itself has already seen key insiders provide damaging testimony. But none of those witnesses occupied the unique position of being married to the defendant and living in the same residence where the alleged crimes took place. Now, however, it's different. This time, the testimony comes from someone who cannot be dismissed as a disgruntled employee or a political operative. The pattern is clear. When the evidence becomes overwhelming, even the closest relationships can't shield a defendant from accountability. So what specifically triggered Trump's legal team to file an emergency motion within 90 minutes of the deposition ending? According to legal experts who reviewed the publicly available court filings, the motion seeks to have Melania's entire testimony excluded from the record on the grounds that it violates spousal privilege. The filing argues that Melania's statements about private conversations with her husband are protected under federal marital communications privilege and should never have been compelled. Here's the kicker. Legal analysts immediately identified a critical flaw in this argument. Federal spousal privilege only covers private communications between spouses. It does not protect observations of actions, conversations with third parties, or events witnessed by others. If Melania testified about conversations she overheard between Trump and his aide, that falls outside the privilege. This wasn't a private marital conversation. It was conduct observed in the presence of others. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone about the emergency motion itself. If Trump's lawyers genuinely believed the testimony was fully protected by privilege, they would have raised that objection before the deposition, not after. The fact that they filed emergency motions after the testimony was given suggests they were caught off guard by the substance of what Melania actually said. Once that testimony is in the record, even if portions are ultimately excluded, the prosecutors now know exactly what Melania witnessed and can build corroborating evidence around it. This puts Trump's defense team in a nearly impossible position. On one side, they need to argue that Melania's testimony should be excluded entirely, which requires them to claim that everything she said was a private spousal communication. That means publicly arguing that discussions about moving boxes of classified documents and conversations overheard with aides were somehow intimate marital communications. That's a nearly impossible sell to any federal judge. On the other side, if they abandon the privilege argument, they're left with no mechanism to suppress testimony that directly contradicts their client's core defense. And here's the tricky part. There's no credible middle ground. Either the testimony is privileged, in which case they need to explain why they didn't successfully block the deposition in advance, or it's not privileged, in which case the testimony stands and their defense strategy is effectively gutted. Either way, the emergency motion signals panic, not confidence. Legal and political analysts are calling this a potential turning point in the case. Lawrence Brennan, a constitutional law professor at Georgetown University, told CNN that the emergency motion filing is extraordinarily revealing. He explained that experienced defense teams don't file emergency motions after depositions unless the testimony was significantly worse than they anticipated. A former federal prosecutor, Sarah Kenworth, added that Melania's testimony, if it stands, could be the single most damaging piece of evidence in the case because it provides direct eyewitness corroboration of conduct that previously relied on circumstantial evidence and cooperating witnesses. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Alan Rothstein, a conservative legal commentator who has frequently defended Trump's legal positions on cable news, acknowledged that the emergency motion filing raises serious concerns about the strength of the defense. He emphasized that while spousal privilege is an important legal protection, courts have consistently held that it does not extend to observations of criminal conduct, and attempting to stretch it that far could actually backfire by highlighting the significance of the testimony. So let's break down what this could mean. First, the immediate legal impact is devastating. If Judge Marlowe denies the emergency motion, which most legal experts believe she will based on established precedent, Melania's full testimony enters the case record. Prosecutors then have a first-hand witness who can place Trump in direct connection with the handling of classified materials on specific dates, in specific locations, making specific statements. That transforms a circumstantial case into one built on direct testimony from the defendant's own household. Second, it creates an unprecedented personal and political crisis. Trump has spent months portraying his legal battles as political persecution, but when the damaging testimony comes from his own wife, that narrative becomes extraordinarily difficult to sustain. Political allies who have been willing to attack prosecutors, judges, and cooperating witnesses will find it nearly impossible to publicly attack Melania Trump without alienating the very base they're trying to protect. A Snap poll conducted by Reuters on February 15th found that 61% of respondents, including 34% of Republicans, said testimony from a spouse would significantly affect their view of the case. A staggering number for a political environment where opinions have been remarkably fixed. Finally, looking ahead, the strategic implications are profound. Trump's defense team now faces a cascading credibility problem. Every argument they've made about the former president's lack of knowledge regarding the documents is now contradicted by a witness they cannot impeach, discredit, or dismiss as partisan. Future motions, plea negotiations, and trial strategy must all account for the fact that the defendant's own spouse provided testimony under oath that undercuts the core defense. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. The ripple effects extend into Congress as well. Multiple Democratic lawmakers have already issued statements calling the emergency motion a desperate attempt to hide the truth. Meanwhile, at least 4 Republican senators have gone conspicuously silent, refusing to comment on the deposition despite repeated requests from journalists. That silence speaks volumes. In Washington, when allies stop defending you publicly, it usually means they've seen something that makes the defense untenable. But beyond the immediate legal fallout, this is really about the fundamental principle that no one is above the law. The institution of spousal privilege exists to protect the sanctity of marriage, not to shield criminal conduct from accountability. If a president or former president can invoke privilege to suppress eyewitness testimony about the mishandling of classified national security documents, it would effectively create a zone of immunity around the presidency that the founders never intended and the Constitution does not support. This scenario is causing absolute turmoil within Republican leadership. Reports from Capitol Hill indicate that senior Republicans held emergency conference calls on the evening of February 14th to discuss how to respond. Some argued the party should attack the prosecution for compelling spousal testimony, framing it as an assault on the institution of marriage. Others insisted that commenting on sealed testimony would be reckless and potentially harmful. The party is fracturing in real time, torn between loyalty to Trump and the growing impossibility of defending against evidence produced by his own family. Meanwhile, Trump himself responded with a series of posts calling the deposition a disgrace and an illegal invasion of his family's privacy. He claimed Melania was coerced and manipulated by prosecutors and branded the entire proceeding a witch hunt on steroids. He specifically named Judge Marlowe, calling her a partisan operative, and accused her of colluding with the prosecution to destroy his marriage and his defense simultaneously. He did not, notably, dispute any specific claims attributed to her testimony. He attacked the process without addressing the substance. That distinction matters enormously in legal proceedings. Stay with me. What comes next will completely change how you view the situation. Here's what makes this even more extraordinary. Trump's response essentially confirmed the severity of what occurred. Instead of calmly stating that the testimony supports his defense or that Melania's answers were consistent with his legal position, the reaction was fury directed at the process itself. When your defense is attacking the existence of the deposition rather than disputing what was said in it, you've already lost the argument. Legal experts immediately flagged the problem. Targeting the process instead of the substance creates an inference that the substance is indefensible. This goes far beyond a single deposition or one legal case. It's about whether a former president can effectively prevent the justice system from hearing relevant testimony by invoking personal relationships as legal shields. If there are no consequences for attempting to suppress eyewitness testimony from the closest possible witness, it signals that political power can override the truth-seeking function of the courts. It's not just about this administration or this case. It's about whether the legal system itself has meaningful access to the evidence it needs to function. If this blows your mind, hit that like button right now. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Melania Trump has provided 4 hours of sworn testimony in a sealed federal deposition. Trump's legal team has filed an emergency motion to exclude that testimony, citing spousal privilege. Legal experts overwhelmingly believe the motion will fail because the testimony involves observations of conduct, not private marital communications. Meanwhile, prosecutors now possess direct eyewitness testimony from inside Mar-a-Lago that corroborates their central allegations. This isn't just another news cycle that will fade away. This is a constitutional confrontation unfolding in real time. What happens next could determine whether spousal privilege becomes a loophole for shielding evidence of serious federal crimes, or whether the courts reaffirm that no relationship, however personal, can override the pursuit of justice. Keep a close eye on this story. Judge Marlowe is expected to rule on the emergency motion within the next 10 days. Prosecutors have already signaled they will oppose any exclusion and may seek additional depositions based on what Melania revealed. Legal teams on both sides are preparing for what could become the most consequential evidentiary ruling in this case to date. And behind closed doors, sources say Trump's defense attorneys are already exploring whether a plea negotiation might now be necessary, something that was considered unthinkable just weeks ago. The stakes have never been higher, the testimony has never been more damaging, and the legal crisis inside Trump's defense has never been more immediate. The evidence is under oath, the emergency motion has been filed. Now we wait to see whether the courts will allow the truth to stand or whether privilege will be stretched beyond recognition to protect the powerful. Every American who cares about the rule of law should be watching this closely. Pause for a second and hit that like button if you're finding value in this coverage.